2 or 3 times a week, I get calls from people who don't understand or would like to understand a little bit more about workers' comp or workman's compensation. We don't handle these at Funk & Associates. We do personal injury law. But I've put this segment together to help people understand what workers' comp is and how it's different than personal injury work. We live in a conservative state, and in Texas, employers are able to subscribe to a workers' comp system. What that means is it doesn't matter if the employer is negligent and someone is hurt, or the employee is negligent and someone is hurt, or God forbid just a random act happens and no one's at fault. The reality of workers' comp is your employer's workers' comp insurance company will pay a portion of the average weekly wage while the employee can't work. Once an employee has reached his maximum medical improvement, he or she is entitled to an impairment rating, and then they get a weekly wage benefit for every % that they are impaired. The trade-off for that is you can never, ever sue your employer. There's one exception to that, and that's a wrongful death with gross negligence. That's rare, but it happens. The other very small exception to that is called a third-party case. We do handle third-party cases. We do handle gross negligence and death cases. Both of those fall under the personal injury umbrella. For example, let's say you're on the job and you turn on a faucet. The faucet breaks, hits you in the eye, and you're blinded. Your employer has workers' comp. Can you sue your employer? Answer, no, based on what we discussed. Can we sue the faucet manufacturer? Yes, under something called a third-party claim. God forbid you have a third-party claim or death at the workplace, call me and I would be glad to discuss it with you personally. The number here in Austin, 512-472-3865, toll free, 1-888-472-3865. Funk & Associates is here for you.